Hello, good morning. Welcome to this panel, Criminal Justice Responses to Domestic Abuse, Recent Jurisprudence of the European Court of Human Rights. I now pass the floor to Dr. Rona McQuigg from Queen's University from Belfast. We're happy to have you and enjoy your presentation.
Thank you very much indeed, Anna, for that welcome, and it's good to be here to speak with you all today. So, as Anna said, the title of my presentation is Criminal Justice Responses to Domestic Abuse, Recent Jurisprudence of the European Court of Human Rights. So the Grand Chamber of the European Court of Human Rights issued its first judgment in a case focusing on domestic abuse in June 2021 in a case called Kurt and Austria. In this judgment, the Grand Chamber set out in detail a number of principles which should henceforth be applied by the court when addressing the positive obligations of states as regards the right to life, found in Article 2 of the European Convention on Human Rights in the context of domestic abuse. This presentation seeks to analyse the Grand Chamber's judgment and the extent to which it has impacted the approach of the European Court of Human Rights in subsequent domestic abuse cases involving alleged violations of Article 2. So in Kurt in Austria, the applicant alleged that the state authorities had failed in their obligations to protect herself and her children from being subjected to violence by her husband, which had resulted in the death of her son. At first instance, the European Court of Human Rights held, however, that the authorities had not failed to comply with their positive duties and that there had thus been no violation of Article 2, a finding which was upheld by the Grand Chamber. So a key question in this case was how the so-called Osman test should apply in cases involving domestic abuse. The case of Osman and the United Kingdom, from which the Osman test was derived, involved a teacher who had formed an inappropriate attachment to a pupil and who had then killed the pupil's father. At issue in Osman was the question of in what circumstances the state could be held liable for failing to take appropriate measures to protect the Article 2 right to life of an individual from a risk posed by another private individual. The European Court of Human Rights stated that for such a positive duty to arise, and I quote, it must be established that the authorities knew or ought to have known at the time of the existence of a real and immediate risk to the life of an identified individual from the criminal acts of a third party, and that they failed to take measures within the scope of their powers which, judged reasonably, might have been expected to avoid that risk. Since the decision in Osman, this statement has been frequently cited in cases in which it has been alleged that state authorities have failed to fulfil their positive obligations to protect the right to life of individuals from threats posed by other individuals, including in cases in which victims have been killed by perpetrators of domestic abuse. However, it soon became apparent that there were difficulties with applying the Osman test to cases involving domestic abuse, particularly in terms of the requirement for the authorities to know or ought to know of the existence of an immediate risk to the life of an individual in order for their duties to be engaged. Essentially, domestic abuse rarely consists of a single incident but usually comprises an ongoing cycle. Thus, even if a risk to life does not appear to be immediate, there is nevertheless a considerable possibility that this could escalate at any point. For state authorities to be under a duty to take preventive operational measures to protect the right to life only where there appears to be an immediate risk in the traditional interpretation of this term may not be sufficient to protect the right to life in the context of domestic abuse. The difficulties in applying the Osmond test in its traditional form to domestic abuse cases were highlighted in a number of judgments of the European Court of Human Rights. For example, in a case called Valiurian in Lithuania, Judge Pinto de Albuquerque of the European Court of Human Rights gave a concurring judgment in which he stated, as regards the Osmond test, that, and I quote, realistically speaking, at the stage of an immediate risk to the victim, it is often too late for the state to intervene. In addition, the recurrence and escalation inherent in most cases of domestic violence makes it somehow artificial to require an immediacy of the risk. Even though the risk might not be imminent, it is already a serious risk when it is present. Likewise, in another case called Volodina and Russia, Judge Pinto de Albuquerque expanded on this point in his opinion, commenting that a real and immediate risk in the context of domestic violence infers that the risk, namely the batterer, is already in the direct vicinity of the victim and about to strike the first blow. Were the test to be applied in such a manner, two concerns arise. Firstly, any protective action offered by the state would be too late. And secondly, the state would have a legitimate excuse for not acting in a timely manner, since it is implausible to assume that the victim will be constantly accompanied by a state agent who may jump in to help. Hence, the immediacy of the Osmond test does not serve well in the context of domestic violence. So, in the first instance decision in Kurt and Austria, one of the judges, called Judge Husinov, gave a concurring opinion in which he agreed with the majority that it would be difficult to conclude that the authorities had failed in their positive duties to protect the applicant's son. However, Judge Husinov commented that what had prompted him to give a separate opinion was that, in its judgment, the court has robustly applied the so-called Osmond test to a domestic violence case, and that having done so, the court has overlooked the peculiarity of domestic violence as a distinctive social phenomenon. According to Judge Husinov, the relevance of this test is questionable in the particular context of domestic violence. That is to say, in cases where domestic violence has fatal results. The judge went on to say that it is widely recognised that domestic violence often constitutes not just an isolated incident, but rather a continuous practice of intimidation and abuse. Therefore, the state authorities should react with due diligence to each and every act of domestic violence and take all necessary measures to make sure that such acts do not lead to more serious consequences. It follows that the duty to prevent and protect comes into play when the risk to life is present, even if it is not imminent. In other words, in a domestic violence case, the positive obligation to protect life can be violated even when the risk to life is not immediate. This means, therefore, that the state should adopt all necessary measures in response to every incident of domestic abuse of which they are aware to ensure that the right to life is not breached, even if the risk to life does not seem to be immediate at the particular time in question. In its judgment in court in Austria, the Grand Chamber afforded detailed consideration to the question of how the Osmond test should be applied in cases involving domestic abuse. The Grand Chamber asserted that the existence of a real and immediate risk to life must be assessed taking due account of the particular context of domestic violence, and then went on to expand upon what it means to take into account the specific context and dynamics of domestic violence under the Osmond test. The judgment noted that an immediate response to allegations of domestic violence is required from the authorities, and that special diligence is required from the authorities when dealing with cases of domestic violence. The Grand Chamber then stated that in order to be in a position to know whether there is a real and immediate risk to the life of a victim of domestic violence, the authorities are under a duty to carry out a lethality risk assessment, which is autonomous, proactive, and comprehensive. In relation to the term immediate in the Osmond test, the Grand Chamber commented that the application of the immediacy standard in this context should take into account the specific features of domestic violence cases and the ways in which they differ from incident-based situations, such as that which pertained in the Osmond case itself. In particular, the Grand Chamber recognised that consecutive cycles of domestic violence, often with an increase in frequency, intensity, and danger over time, are frequently observed patterns in that context. If it is established that there is a real and immediate risk to the life of one or more identified individuals, the state's positive obligation to take operational measures is then triggered. The Grand Chamber asserted that the toolbox of legal and operational measures available must give the authorities involved a range of sufficient measures to choose from, which are adequate and proportionate to the level of lethal risk that has been assessed. So, since the Grand Chamber issued its judgment in court, the European Court of Human Rights has found violations of Article 2 in a number of cases involving domestic abuse. These include Felix in Georgia, A and B in Georgia, Landy in Italy, and Y and others in Bulgaria. These judgments all indicate clearly that henceforth the European Court of Human Rights will approach domestic abuse cases involving Article 2 through the lens of the principles set out in court, namely the need for authorities to react immediately to allegations of such abuse, the need to carry out an autonomous, proactive, and comprehensive assessment to establish whether there is a real and immediate risk to life, taking account of the domestic abuse context, and should a risk be identified, the need to take adequate and proportionate preventive operational measures. This may lead to a more uniform approach being taken by the court in its consideration of such cases. Nevertheless, in the majority of these cases, it is very likely that the court would have found violations of Article 2, even if the judgments in these cases had been issued prior to that of the Grand Chamber in court. However, it is possible that had the judgment in Y and others and Bulgaria been issued prior to that of the Grand Chamber in court, a violation of Article 2 may not have been found. In Y and others in Bulgaria, the first applicant's daughter, referred to in the judgment as Mrs. V, had been killed by her husband, who was referred to in the judgment as Mr. V. In 2014, Mr. and Mrs. V had stopped living together and Mrs. V had moved into her mother's flat. In November 2016, Mrs. V reported to the police that the tyres of her car had been slashed and that she suspected that Mr. V had been the perpetrator. She explained that she and Mr. V had had an argument 10 days previously, during which he had threatened to kill her, that Mr. V owned a gun and that she feared for her life. Upon being questioned by the police, Mr. V denied slashing the tyres, and given that there were no eyewitnesses to the incident, no criminal proceedings were issued. In January 2017, the first applicant made an emergency call stating that Mr. V had come to the flat and was acting aggressively. Police officers arrived and reported that they had not witnessed an argument, but they had cautioned the first applicant and Mr. V to act lawfully. In February 2017, Mrs. V complained to the police that following an argument, her husband had pursued her, first by car and then on foot. She had met with him in his car at his request to discuss their daughters. Mr. V was summoned to the police station and cautioned to refrain from making threats or being violent towards his wife. Mrs. V then applied for a protection order, and the district court issued an interim order the following day, which was later followed by a final order under which Mr. V was barred from coming within 100 metres of his wife. In August 2017, Mrs. V made an emergency call stating that her husband was in breach of the protection order and that he was driving behind her car. She then told the call handler that her husband had disappeared from view. The call handler advised Mrs. V to lodge a written complaint with the police, which she did that evening. And the next day, Mrs. V lodged a complaint with the district prosecutor's office, stating that her husband owned a gun and that she feared for her life. After leaving the district prosecutor's office, Mrs. V went to a coffee shop where her husband appeared and shot her 5 times, and Mrs. V died instantly. In applying the principles set out in Curtin, Austria to the facts of the case, the European Court of Human Rights stated that the only occasion on which the police had responded immediately was in relation to the incident in January 2017. In relation to the quality of the risk assessment which had been carried out, the court stated that there was nothing to suggest that the police had analysed Mr. V's conduct in terms of what it could indicate regarding his future conduct. Rather, the police seemed only to have been concerned with the question of whether Mr. V's acts should result in a public prosecution, and appeared to have handled his wife's complaints without appreciating that the allegations suggested that the case concerned the special context of domestic violence and its typical dynamics. In terms of whether the authorities knew or ought to have known that there was a real and immediate risk to the life of Mrs. V, the court was of the view that had a proper risk assessment been carried out, it was likely that the authorities would have appreciated that Mr. V, who was alleged to have access to a handgun and had been repeatedly displaying the signs of an angry, violent and excessive attitude towards Mrs. V, could pose a real and immediate risk to her life, as those notions are to be understood in the context of domestic violence. The court concluded that the authorities should have known of a real and immediate risk to Mrs. V's life, and that they failed to take measures at their disposal which judged reasonably might have been expected to avoid that risk. There had thus been a violation of Article 2. It is arguable that in the absence of the principles set out in Curt, a violation may not have been found in this case. In Y and others, the court frequently referred to the context of domestic abuse And if the facts of the case are taken out of this context, it is debatable whether the court would have held that the authorities should have been aware of a real and immediate risk to life. In particular, prior to the murder of his wife, it seems that Mr. V had not actually engaged in physical violence towards her. It is, of course, critical to bear in mind that domestic abuse does not consist solely of physical violence. However, if the context of domestic abuse is removed from the case, it is debatable whether the authorities should have been aware of a real and immediate risk to life. The complaints made to the police could be said to have been small in number, and only 3 of them related to incidents involving Mrs. V. The first of the complaints involved the tires of a car being slashed and allegations of death threats having been made 10 days previously. However, given that there were no eyewitnesses or evidence from surveillance cameras, the decision to take no further action beyond questioning Mr. V may have seemed reasonable in the absence of the domestic abuse context. It appears that the failure to comply with the principles set out in court regarding the need to carry out a speedy and comprehensive investigation of all allegations of domestic abuse and the requirement for death threats always to be taken seriously in domestic abuse cases were crucial to the court's analysis of the authorities' response to this complaint. The second complaint made by Mrs. V related to her husband pursuing her, first by car and then by foot. Mr. V was summoned to the police station and, despite denying having threatened his wife physically, was some caution to refrain from making threats or being violent towards her. Whilst it could certainly be argued that charges should have been brought against Mr. V, if this incident were taken out of a domestic abuse context, again, it may not indicate a real and immediate risk to life, particularly as there was no actual physical violence involved and the victim had voluntarily met with the perpetrator in his car prior to the incident. Mrs. V made her third complaint at around 7 p.m. on the evening prior to her death. Again, there was no physical violence involved, and the complaint related to Mr. V following his wife by car. If taken out of the domestic abuse context, it appears that the incident may not indicate a real and immediate risk to life. The complaint which Mrs. V made to the district prosecutor's office was lodged only around 1 hour before her death, and if removed from the context of domestic abuse, it may have been reasonable for no action to have been taken within this time period. However, again, the failure to comply with the principles set out in court that the authorities must respond immediately to allegations of domestic abuse was significant. So, in conclusion then, the judgment of the Grand Chamber in Kurt in Austria certainly constitutes a landmark in the jurisprudence of the European Court of Human Rights on domestic abuse, and in particular as regards the court's use of Article 2 in such cases. It is now beyond doubt that although the Osmond test should be used, it must be applied in such a manner as to take account of the specific circumstances of domestic abuse. It seems from the judgments that have since been issued by the court that henceforth the principles set out by the Grand Chamber will generally be followed closely by the court in domestic abuse cases involving Article 2, thus leading potentially to a more uniform approach being taken by the court in its consideration of such cases. Also, the application of these principles could lead to the court finding violations in circumstances in which it would not have done so prior to the Grand Chamber's judgment, as may have been the case in Weil and others in Bulgaria. Thank you very much.
Thank you very much for covering this important topic. There are no questions for now, but we can continue the discussion on the WOBA platform during the conference. Um, so it was really interesting to listen to you, and we hope you enjoy the rest of the conference. Thank you very
Thank you
much.
very much indeed, Emma. Thank you.
Have a great day.
You too.